The Court of Appeal First District is now in session. All those with cause to plead, to all nine, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. Please be seated. Thank you. Welcome to oral arguments today. Just an announcement after the first case, we're going to take a coffee break. We invite the lawyers and others interested in joining us for a coffee break, which will be in the comments area around on this floor. So after the first break, we will take about a 20-minute recess. Are appellants ready to proceed in the first case?
We are.
I'll call the case of Cannon versus Thomas.
May it please the court. My name is Jennifer Shope Richardson. I'm from the law firm of Creed and Gowdy. I'm here today representing appellant, respondent below, Paris Destiny Cannon. This case presents a simple legal error. The final order granting a permanent injunction for protection against repeat violence was not supported by the allegations of the petition or the facts presented below. Secondarily, the term of the injunction permanently banning respondent from attending any Duval County public school is both overbroad and unconstitutional. If this court determines that reversal is required based on the first issue, it need not reach the constitutional issue.
Let me ask you, Counselor, if there's two plausible interpretations of the statute, why wouldn't we go with the one that protects the victim here?
There are several reasons to understand that the statute clearly provides that two acts of violence are required. The first and the easiest for us to understand is the plain language of the statute. It directly defines the term of repeat violence as meaning two incidents of violence.
Okay, well, and I think that's given a definition, but what we're focusing on today is the language added in 1999 that deals with the standing of a parent to bring this action on behalf of a minor. It was added separately, standalone language in 1999. My concern is that the two cases you rely upon were pre-1999 cases. So we essentially have a case of first impression here, don't we?
Yes, Your Honor. This exact argument has not been made before, the argument that Appellate is making. I would have to concede that. But we find no legal support in any other authority or reasoning for applying the statute in the way that Appellate has presented. That language of for protection against repeat violence was in the statute before it was amended and remains in the statute now.
Well,
So it wasn't added specifically for children.
Well, I'm maybe I'm asking too many questions, but the language that was added uses the specific word against repeat violence. The statute as it existed before 1999 talked about protection when there had been two or more acts of violence. Here it says the parent can come in on behalf of a minor and protect against repeat violence, suggesting that perhaps the legislature intended that parents can come in and protect their kids before they're beat up twice.
Actually, Your Honor, the language against repeat violence was in the statute before 1998. It's repeated in that term, for the minor against repeat violence. But if you look at the 1998 version of the statute, it does say for protection against repeat violence.
Were any other changes made as a result of that amendment to suggest that there is an exception for minor children? I mean, in other words, subsection 2 wasn't changed, and that reads that there is created a cause of action for an injunction for protection in cases of repeat violence. Were any changes made to that particular subdivision?
No, Your Honor, no changes were made to that particular subdivision. If we reference the laws of Florida, Chapter 9, Chapter 9-193, which Appellate raised in the answer brief, you can see that no changes were made to that language.
Well, let me ask you a question. The final judgment does find, and I realize this is a form final judgment, but it does find that petitioner is a victim of repeat violence. So it is, of course, undisputed that the beating was one incident of violence. But in the record, we are allowed to go through the record and see if there's other incidents of violence, correct?
Correct, Your Honor. The case law has said if there's competent, substantial evidence of a second incident of violence, as in this case.
So let's talk a little bit about the Facebook threat that was entered into evidence, and we have that threat of communication. Why does that not constitute a separate incident of violence?
It does not constitute a separate incident of violence. The one it's most likely to have been would be an assault. An assault requires 4 elements: an intentional threat to do violence, apparent ability to do so, an act which creates a well-founded fear in the person receiving the threat, and number 4 is imminence. Here, most clearly, we don't have any imminence between that threat on Facebook being made. We don't have any facts saying we believed it was about to happen right now.
But I thought
We also don't have an overt act.
I thought the victim knew that this student had beaten other people before, and we have a threatening statement made in the Facebook post. Why wouldn't that create sort of an imminence of potential violence?
Your Honor, her direct testimony during the final hearing was that she was not in fear from the Facebook post, and her mother's testimony was the same. They dropped her off at school the next day, just like they always did. But
There's a case that no one cited here from our court earlier this year that said that if you post a threat on Facebook, the act is complete, the crime is committed, even whether there's fear or not. Why doesn't that apply here?
the act
That's
of
the
assault.
O'Leary case.
The act of assault.
And no, it's a reference to 83610. It's a statute describing written threats. It hasn't been raised, but it's by either party, but it's a statute that does not require fear or an overt act other than what we said in the case is that once you post the threat, then, and it's read, then it constitutes a crime under 83610. Now then that would obviously lead to the question of, well, can that act be a second act of violence as defined by this statute? So that's the question.
Your Honor is onto something there, because the legislature didn't leave us to guess as to what constitutes violence. They define the specific acts of violence under Section 1A of the statute, 784.046. And there's no special exception to the usual rules of assault for Facebook threats.
The statute does provide a catch-all, though, at the end. It says, or any criminal offense resulting in physical injury or death. So I guess the suggestion would be, by extension, was the Facebook threat, did that result in physical violence or injury?
I hear the question, Your Honor, and we did cite cases in our brief which say if two acts are so separated by time and space that they, could not constitute one act, then they're not one incident. So in other words, you can't merge the threat and then the battery the next day to complete the assault.
Going back to whether or not she had reasonable fear as a result of the Facebook threats, you're correct in your assessment of her testimony at the hearing that she said she was not afraid. But that's inconsistent with what she put in her Facebook communication, wherein I'm going to delete some of the profanity, but she says, I'm scared of you. I ain't going to lie, you would murder me. So I'm sorry if you saw something or heard something that I didn't do. That indicates to me that she did have a reasonable fear that the individual would carry out the threat. So how do we reconcile her testimony and what's in the Facebook post?
First of all, the Facebook posts have a lot of authenticity problems, but then we have the live testimony in trial from not only her, but also her mother, who seemed fairly in touch with who her friends were and what their interactions were like. The consistent testimony was that these girls were best friends 2 weeks ago. You have young girls going back and forth in a conversation, there's also no evidence that the trial court found that Facebook post more credible than her actual testimony in trial. The trial court didn't make findings, so.
What is our standard of review?
It's a mixed standard of review. The questions of fact, such as whether something happened or not, are governed by the abuse of discretion standard, but the facts must be supported by competent, substantial evidence. To the extent that we're interpreting the statute and whether 2 acts of violence were required, that's subject to a de novo standard of review. And Appellate cited the same case that we cited, that Operation Rescue case, for that proposition.
You mentioned they were friends, and the record shows they were friends, and even the victim had been over to the home to deal with the other student here. What effort has been made, if any, on behalf of the parties on both sides to mediate the matter, just work it out? I mean, under our appellate rules, we can order mediation, and certainly in the appellate rules, there's nothing to prevent you two getting together and working something out with the Duval County School Board to make this work for everyone. Has anything been done in that regard?
I have not been apprised of any desire for mediation out of the petitioner or respondent.
I see you're in your rebuttal time.
Thank you, Your Honor.
Counsel. My name is John Phillips, and I represent Lucia Thomas, who's the mother of Mary Jewett. I'll be referring to Mary, and you, Your Honors, are very familiar with the case by your questions. Let me briefly address the right to an education and get that out of the way. We find no case that refers to the right, the fundamental right of an education. It's referred to as a value. And the way we look at it is a right is an entitlement. A value
Counsel,
is a treasure.
this injunction is overbroad. I mean, what's your authority for a circuit judge to be able to say you can't ever go back into the school system? Isn't that about as far out as you can go?
Your Honor, it's actually more relief than what we requested. But this judge, and it was in last week's paper, has been calling out the school board.
Oh, yes. Let's just stick to the record.
Right. And it related to the mediation question too, but there's an issue here that this judge is unhappy with the ability of the school system to protect kids.
Are you conceding then that the injunction is overbroad, and not as a constitutional issue, but the argument that it's overbroad, the trial court lacked the authority to issue an injunction broader than was necessary to protect the victim in this case?
No, Your Honor, and here's why. The issue within a district, within a school system, is that kids are going to be, from different schools, are going to be bus stops, ball games, field trips, which actually happened in this case during the pendency of the stay. The kids are going to be intermingled, and the judge found, without specific ruling, but the judge found that Paris Cannon presented such a threat that he didn't want Area Jewett and Paris within the same parameters.
Well, why not let the school district make that decision? Why not have the injunction say you can't have this sort of contact with each other and leave it up to the school district to work it out? Because they're on notice that there's been this act of violence against a student in the school in the morning before school. And I would suspect that they certainly don't want to have any follow-up litigation, so why not for another act of violence, why not let them take the lead on it?
Certainly, Judge. And the testimony was that there had been that Area was aware of another incident or had seen another incident at a bus stop and also at that school. And so I think the judge kind of threw up his hand and said, well, if there were other incidents at bus stops and schools and this one that she was lured off campus, that there's a bigger problem here than just.
Why don't we go back, why don't we turn to the first issue, since
Okay.
we won't need to get to the second issue if we find the first issue fails as a matter of law. So why don't you tell us why the statute doesn't require 2 acts of violence in your opinion?
Yes, Your Honor.
Obviously, it's going to focus on that one sentence that talks about a parent or a guardian has a right, has standing essentially, to obtain an injunction for protection against repeat violence. I don't see any indication that the legislature intended that did not require 2 acts of violence, but please feel free to educate me.
Yes, Your Honor. And as Judge McCarty stated, this is a case of first impression. This is the first time this has been brought up and scrutinized. If I'm a custodian at a pool and a swimmer gets MRSA, and my boss tells me, all right, you got to protect against further incidents of MRSA, that means there's only been one incident, and I'm charged with protection against further incidents. The plain language is what we have to go by.
Well, but what you're doing is you're pulling out one phrase in the overall statute. And of course, we have to consider the statute as a whole. And there's multiple references in the statute, including subsection 2. There is created a cause of action for an injunction for protection in cases of repeat violence. Subsection 4A, the sworn petition shall allege the incidence of repeat violence. The petition that's prescribed references repeat violence. So, I agree. In isolation, the language that you're pulling does suggest only one incidence is necessary, but we have to reconcile that with the broader statute. So help us do that. Help us understand how we can do that.
I don't know the answer to that, Your Honor. It's a poorly written statute from that perspective because it leaves it open to interpretation. And when the only language that I've seen in that statute related to the protection of minors, which was amended, and again, I agree with counsel that it was in there once and it was put in there twice, I think, during the amendment. But the only charging language we have for protection of parents of minors is for protection against repeat violence. So the definitions of repeat violence and all of the other language related to that really doesn't resolve our question, which is what does the plain language of what the intent of a repeat violence statute related to minors means? And it's just a poorly written statute. Now, that said, we do, and Your Honor brought up the Facebook point that I was going to admit that she did say you were going to murder me, and she did say I am in fear. And additionally, after this, there was testimony that Area Jewett received some chatter that there was going to be another assault if they were back in the same school. So we contend there were 3 incidents before, during, and after.
Okay, so now we're moving from the tipsy coachman argument for affirmance to there was multiple incidents of violence. So can you cite for us the criminal offenses as the statute defines them that are the additional incidents of violence?
Yes, Your Honor. The citation as the Facebook post was left out of the original record. It's the supplemental record, so I guess I cited a supplemental record. But Your Honor nailed the point, which was Paris saying, I'm going to beat your expletive. And Ari saying, you know I'm scared of you. And then later on saying in that sentence, you would murder me. In the first DCA, and I wasn't aware of the O'Hara case. O'Leary case. But I have seen other cases where this very court, has said that cyber abuse and postings can arise to the level necessary for triggering the repeat violence. But in that case, it didn't get to that question because there was not a second issue of violence. So that's number 1 for us. Number 2, I can go through as far as the violent act itself, but counsel stipulated there was a severe beating of the record on page 145. After, on page 134 of the record, Area stated in testimony she feared for her life because she heard threats, again on 134, that she was going to do it again. So we have 3 distinct acts, one of which is stipulated. The question is, does the Facebook post trigger the protection should we need 2 incidents of violence or more? Or does the threat in these children who were involved in the overall gathering trigger that 3rd measure? And what we're dealing with injunctions is a pretty sad situation for kids. If it's a domestic violence injunction or it's a family injunction, all you have to show is imminent fear. And what the legislature did in adding sexual used to be within repeat violence. And it said, well, wait a minute, we don't need 2 incidents of sexual assault to protect a sex victim. So what we feel that the legislature did is do the same thing for kids and say we don't feel like kids need to be a second-time loser to be able to have some degree of restraint when the criminal law for bullying really isn't a criminal law against the bully. And civil law is just for remuneration. The only thing we have here is this injunction law. And so, with kids that are unprotected killing themselves and dealing with where we are in bullying law, if we're reading this wrong, we hope the legislature will amend it and make it this way. But I don't think there's any other way you can interpret or protection against repeat violence except to say the plain language is what it is.
Would you concede that there are other opportunities within the criminal justice system or within the juvenile justice system that would provide protection for the public for children that have been overly aggressive in the school system?
I'm not privy to what's going on. I just know what Judge Davis has jumped in and said. And Judge Davis feels that not to be the case very publicly. And again, I know that's not a part of the record here, and I really am at a loss of how to go into it. But the reason he did this and the reason he explained it afterwards was for that very reason. He's frustrated with the status of affairs with prosecution of juveniles and the way the court's hands are tied. And civil really doesn't do anything here because, what's one kid going to go sue another kid for lunch money, or her parents? It's almost...
You're making very interesting points and obviously very important points. And obviously the safety of children is of paramount concern in all branches of government. But the arguments you're making are essentially legislative arguments, or the arguments you're referencing to outside the record, essentially. But aside from that, they're policy arguments as to why the legislature should provide for an injunctive relief based only on one act of violence. But obviously you're relying on the plain language, and it does seem, it certainly could be described as ambiguous. If we find it's ambiguous, how does that work in the calculation?
I'm sorry, Your Honor?
If we find this statute is ambiguous, i.e., quite frankly, reasonable people can look at this sentence and say, well, they could have meant against repeat violence only requires one act of violence, but the legislature certainly did not make that clear. So it's an ambiguous statute. If it's an ambiguous statute, do you prevail or do you lose in this question?
I think we would prevail, Your Honor.
Why is that?
Because you would look at repeat violence, protection against repeat violence, as being a floor of one incident. And so
I'm saying if it's ambiguous, if that sentence can be read two equally plausible different ways, which party in this case prevails on this issue?
I think Area Jewett, because you have to go to the least restrictive interpretation.
Why?
Because otherwise, you're saying it's ambiguous, but you're holding that she has to reach a higher standard.
I'm not.
than the clear language.
I'm just
And I don't
asking
mean
you to
hold it,
fill
but
in
I
the
mean-
blank for yourself.
Right. It's a tough question, and when we looked at this,
Well,
we didn't know what.
Let me ask you, if it's ambiguous, and you look at this language here, I would think the answer would be something along the lines of, well, the statute doesn't require us to show no acts of violence, we have to show something. I mean, you're not saying that you don't have to show any acts of violence.
No,
So that's a possible interpretation of where you're coming from.
For protection against repeat violence, and you can look at it in any analogy, if for protection against a repeat touchdown is a defensive act, it means there's been a touchdown. Whether there's a second touchdown or a third touchdown or a fourth touchdown, how many touchdowns there's been is the question for the judge to look at. But we say, based on the clear language, for protection against whatever the incident is, MRSA, touchdown, whatever, where...
But you admit, don't you, that if we interpret the statute that way, that changes the entire context of the statute. The statute is a statute regarding injunctions for repeat violence. And we would be interpreting that sentence, and I'm not stating whether we will or we won't, but we would be interpreting that sentence to carve out an exception based strictly on the two words against repeat, with no other indication in that statute, as Judge Ray pointed out, looking at the statute as a whole. No change in the definitional section, no legislative history on that sentence at all.
I respectfully understand your position, but I don't think you have a choice. I mean, from this perspective, it says, and it gives adults one standard. It says if any person who is the victim of repeat violence, they were very specific with their words for adults. They are the victim of repeat violence, which means 2 or more incidents. Or the parent or legal guardian of any minor child who is living at the home and who seeks an injunction for protection against repeat violence. It's very different of the standard of adults and children. And so I think if this court rules that it's ambiguous, we just set the bar lower for children as the wording holds.
I have 2 other questions. First, the mediation question. What's your response?
The issue is, in this case, with some of the contention between the judge and Duval County Schools and...
Well, the judge would, the mediation would involve the clients and perhaps the Duval County.
Certainly, and my client moved to Texas because of
That's my next
uncertainty related
question.
to this issue.
So why isn't this moving?
Because she wants to move back. But because of the stay of this court, she wasn't certain, because they were both elevating to high school. And so she wasn't sure where this would leave her.
So in the interim here, we have no data point to see how the school district would handle this situation vis-a-vis the 2 students. In other words, they have not been in the same school system. There's a stay. So
They were in the same school system for a few weeks, and there was a field trip where they were both, and again, we're getting on the record, but where they were both bused down to Orlando. And
Counsel, I'll let you briefly conclude. Your
Thank
time's
you.
expired.
And they both ran into each other, and there was imminent fear from that. So that's why her mother pulled her out and sent her to Texas.
Thank you,
Thank
counsel.
you. Thank you.
Judge Makar, just to further respond to your last question, it is within the court file that we know how the school district would take care of the issue of 2 girls being in the same school system. They said they would make every effort, or they would ensure that the girls go to different schools. The superintendent said that in an affidavit. That's within the record.
So assuming there were 2 acts of violence and the injunction was proper, what would the injunction say as to the scope of the constitutional scope?
If we're just talking about terms of the injunction, okay, if it's proper, it can say, respondent may not have contact with petitioner, respondent must stay X number of feet away from petitioner. The judge could tailor that to whatever he needs. It could say, respondent may not attend the school attended by petitioner. Our contention is just that it could not say permanently respondent can't attend any of the 23 Duval County middle schools.
Let's go back to the sentence against repeat violence. We've had a chance to hear your opposing counsel's oral argument on the floor. Tell us why, again, you think that should not be read as the opposing counsel says.
I think to the extent that that sentence could be ambiguous, reading the word against as opposed to right after 2 acts of repeat violence. That hole has been filled by the court system. We cited several cases explaining that 2 incidents of violence are required, and every DCA has held that.
Well, but that's not accurate. There's no, you just said it's a case of first impression. The cases you cited in your brief were pre the amendment to the statute. So there is no binding or even a persuasive case on directly on this point.
Those cases have directly interpreted the words "for protection against repeat violence." Though they haven't in the context of the standing clause, they have directly addressed this issue of what is it that we're looking for in repeat violence. It's not just the possibility of a second act of violence. Injunctive relief is only available for what the legislature gives the court authority to issue it for. So in this case, we just don't have that. The legislature's been fairly clear. In fact, even in the statute as it stands today, Judge Makar, if you look to section 7B of the statute, where it says what relief the court may grant if it deems proper, it says it may order such relief as the court deems necessary for the protection of the petitioner, not the world at large.
Well, I don't have a problem with the argument you're making about overbroad. I think that's an important issue.
Your Honor, I did want to address the statute, section 836.10 that you mentioned, and the O'Leary case. The O'Leary case does not hold that a threat under that statute qualifies as an act of violence. It holds that the Facebook post constitutes sending a threat. So, to the extent that you're concerned that that may qualify as an act of violence, it's not enumerated in the statute, and I don't think that.
Well, the
is what
statute,
case
right, the
was.
statute doesn't refer to threats,
Right.
the definitional section. But the catch-all phrase, as earlier mentioned, talks about criminal offenses that result in physical injury. Under 836.10, we could look at that as a criminal offense, the Facebook posting that the appellant did. Then the question becomes, did that posting result in physical injury? That's the only way that can be interpreted.
It did not.
And then could I ask, on the mootness issue, what's your position on mootness?
I'll allow you to answer the question.
From appellant's perspective as well as Appellee's perspective, this case is not moot. If my client violates this injunction, she's subject to criminal sanctions.
Thank you, Counsel.
So,
Your time's expired.
thank you.
But, sorry, I'll allow you to sit down before I advise. As indicated earlier, we'll be in recess. Thank you both.